Today I will be examining the concept of grace periods in patent law. This will comprise of examining what grace period is, followed by looking at what some of the problems of having a statutory grace period in patent law are. So firstly, it is important to understand what a patent is. A patent refers to a right or title for a specified period of time, more commonly the sole right to exclude others from making, using, or selling an invention, innovation, or research. This occurs by way of application, approval, and subsequent registration. In the majority of international jurisdictions, a patent must be obtained prior to the public disclosure of the invention in order for protection to be afforded. A grace period refers to a period of time prior to the lodgement of a patent application in which disclosures of the invention, innovation, or research can be made without affecting the ability of the inventor to subsequently apply for a patent. More specifically, the grace period was introduced in the 2002 amendments to the Patent Act 1990 in Section 24. What it does is provide that when deciding whether an invention is novel or involves an inventive step, or an innovation involves an innovative step, the fact that the information has been publicly available with or without the consent of the patentee must be disregarded, so long as a complete application for the invention is made within 12 months, aka the prescribed period. In terms of problems associated with grace periods, there are three concepts that I will address. These are non-recognition by some overseas countries, the potential for legal uncertainty, and the 2012 Raising the Bar amendments. Whilst Australia does have a statutory provision allowing for a grace period in intellectual property, it is a considerable issue for inventors, innovators, and researchers that not all countries, particularly Europe and the majority of Asia, offer the same disclosure protection. Consequently, this means that any act which renders the invention or innovation as being publicly available prior to the filing date for a patent will effectively prevent the invention from being patented in other countries due to not satisfying the strict requirement of novelty. For over 4 decades, there have been numerous international discussions and draft proposals regarding the introduction of a grace period for patents. The World Intellectual Property Organization drafted a proposal in the 80s, which was ultimately rejected in 1991. A lot of the opposition to an international adoption of a grace period is regarding perceived uncertainty. However, since the rejection of the proposal, the United States have changed their stance on grace periods, and Japan also introduced a similar provision, which has given the international discussions some more momentum. Some critics of grace periods argue that allowing such a provision creates legal uncertainty for both patentees and third-party investors. This is through expanding the period of time in which the outcome of an application is unknown from 18 months up to 2.5 years, through the additional 12-month prescribed period where the idea may be publicly disclosed on top of the already time-consuming assessment period. This perceived uncertainty is part of the reason for Japan's prescribed period being for 6 months rather than the 12 months which is the case in Australia, the United States and Canada. However, since the introduction of the grace period in Australia 14 years ago, there has been no real problem based on uncertainty, and research indicates that inventors are not less likely to disclose inventions. Likewise, investors and competitors have not become more constrained in their operations. Rather than incite uncertainty, the grace period has effectively provided a safety net for inventors to ensure protection is not compromised by premature disclosure. What is clear is that the main constraint on full realisation of the grace period remains to be the lack of international uniformity. A prior problem which has since been resolved in relation to grace periods was examined in Mac Innovations Australia Proprietary Limited and Rojaco Proprietary Limited in 2010. Here the issue was whether the prescribed period in which an application must be lodged should be measured from the time a provisional application was submitted or from the first public disclosure of the invention. The court found that a provisional application is an application for a patent under the Patents Act, and therefore the term patent application, as used in Section 24(1), should be broadly construed to include both provisional and complete applications. The amendments to the Patent Act 1990 in 2012 included a change to the grace period contained in Section 24 of the Act to provide that a complete application is required within the prescribed period of 12 months from the first public disclosure in order to invoke the grace period. This stands to mean that inventors seeking a patent cannot rely on having lodged a provisional application in order to protect their invention or innovation. In conclusion, it is noted that whilst there are some potential problems associated with having a grace period in patent law, in the majority of cases these do not present great issues. As has been highlighted, the primary issue in regards to grace periods is the lack of international uniformity, and it will be interesting to see whether this changes in the next few years.